I'm happy that you all are here because this topic, those who have already studied natural resources, it's a familiar topic to them. But those who have yet to study that subject, I'm basically keeping it as simple, just to show you the politics over permanent resources, permanent sovereignty over natural resources. When I say contestation in developmental practices, I will take up international investment law, international human rights law, and I will try to show you, obviously very briefly I will keep it, but what's the contesting point there? And when we are saying contest, it is contest between whom? That is the major question. Now, in Badinter arbitration, next slide. In Badinter arbitration, and am I audible like this? So, in Badinter arbitration and in Montevideo Convention, in these two, sovereignty was considered as one of the essential element of state. Am I audible to everyone? Okay. So, segmented into different nations. The matter was referred to Robert Badinter. It is a 1962 United Nations General Assembly resolution. 1962 United Nations General Assembly resolution. And in that resolution you will find it is very clearly mentioned that a nation may use, possess, control, dispose, regulate their own natural resources. Not only this, they can nationalize it, provided when they are nationalizing it, they have to pay adequate compensation to the countries who will suffer because of this nationalization. This is a simple proposition that is there in 1962 resolution. Now, what is the point of contestation? Now, with the passage of time, there were many states that were developed. Some have nots. Now, these new states which have developed, they were asserting their claim over their own natural resources. There is nothing to assert, yes, we can say, but yes, they were stating it is our natural resources, and since it is our natural resources, that means we have a full claim over our natural resources. There is nothing, these terms are non-negotiable. They are not going to take anything less than that. That is how this entire issue developed. Next slide. Now, this will be the thing that will be a major part of my presentation. First thing that you have to see is that when I am saying permanent sovereignty over natural resources is non-negotiable, it is my right, come what may. At the same time, there is a correlative duties also. When I am going for expropriation or nationalization of these resources, that means I have to think about the welfare of the people. That is the prime concern. That is why correlative duty means it is welfare zone, you have to think about the welfare of the people. Now, this permanent sovereignty over natural resources, it is also connected to international human rights law, international investment law, and lastly, how it has travelled from a simple principle to a fundamental rights of the state, balancing all rights and duties. So, briefly I will go into the development of the principle of permanent sovereignty over natural resources. This is how it has developed. In 1960, it was in the form of concerted action for economic development of economically less developed state. After that, you will find in 1962, it was permanent sovereignty over natural resources. Now, one thing you have to understand about permanent sovereignty over natural resources. It is a soft legislation. Legislation or resolution. Why it is soft? Please see the opening line. Use, possess, control, dispose, regulate, nationalize your own resources. First thing. Second, what does it say? In the case of nationalization, obviously it has to be for the benefit of people, no doubt about it. And third, it is saying that in case of nationalization, adequate compensation shall be paid to the country who will suffer because of this nationalization. Now, one catching point here. Normally, I think 4th and 5th year I can expect fork in the road clause arbitration, right? Now, 1962 resolution states that first the investor nation, in order to claim compensation, they have to exhaust the local remedy, domestic law. If they are not happy with the domestic law, then they can opt for international arbitration. Quite opposite to fork in the road clause, okay? That is the reason why throughout you will find, when I will discuss, you will see, 1962 resolution, no one had no problem. All the problem they will face is with respect to Charter on Economic Rights and Duties of the State. So, from 1960 resolution, next you will find in 1974, new international economic order. New international economic order, it also had the element of 1962 resolution. Please remember, permanent sovereignty over natural resources 1962. I will now, from now onwards, I will refer it as 1962 resolution. Okay. So, new international economic order, it also had the element of 1962 resolution. Now, where does the contestation comes? Point of contestation here was that the Western European nation, what they did was that they did a lip service support to new international economic order. Lip service means it is something we require. You know, developing nation required this kind of charter, it must be there. They supported it. But at the time of voting, none of them appeared. They abstained from voting. But anyhow, the developing nation who were there, they were at least happy that new international economic order is there, and in that there is an element of 1962 permanent sovereignty over natural resources. So they were happy about the fact that permanent sovereignty clause is there, means we have sovereign rights over our natural resources. That is the reason you will find the next step is 1974 Charter on Economic Rights and Duties of the State. Now, Charter on Economic Rights and Duties of the State, you will find it has a very strong statement. What is the strong statement? Why Charter was not that popular? Charter was not popular because Charter on Economic Rights and Duties very clearly states, is its clause, section 2, subsection 2, clause A will very clearly state that investor nation, when it will come and invest in our country, their investment shall be regulated. Clause B of section 2, subsection 2 is further saying that not only it will be regulated, it will be under the constant supervision of the investee state. And third clause, final clause C is saying that in cases of any compensation, what is to be done? It shall be according to domestic law, and that too, priorities shall be given to the domestic need. Based upon that, compensation shall be given to the investor state. That is the reason why child was never popularized, it was never been accepted. You will find the comment that was made by arbitrator with respect to child in the case of Texaco arbitration. Texaco arbitration, it was between Texaco Petroleum Company and Libya versus Libya, you will find, where the arbitrator is very clearly stating that we have nothing to do with, no problem, we have absolutely no problem with 1962 resolution. We recognize and we acknowledge the fact that a nation has permanent sovereignty over their natural resources. Understand the background of Texaco arbitration. Nationalization of US property, US assets by Libya. Sudden nationalization that was done. Are you getting it? Sudden nationalization means now compensation has to be paid. Now, that is where Libya was not ready to pay. Afterwards, there were settlement. That's a different issue. At that time, it was not a settlement. Beautifully arbitrated tribunal that was there, they beautifully analyzed the situation. First, does Libya follows international law? General principles of international law? Yes, it follows. Then a part of general principle is that nobody has forced Libya to enter into this contract. Out of their own free will they have entered. Getting it? Now they cannot take back, and now they cannot go ahead with the nationalization. Fine, under 1962 you nationalize it, provided you pay prompt, adequate and effective compensation. If that compensation is done, you have every right, you have a permanent sovereignty, but you cannot take away my right, that means my compensation. That is the point where you will find this contestation that is happening. Now, after that you will find gradually how permanent sovereignty it has come to surface as a fundamental rights of state. Gradually what happened? When the drafting of human rights covenants were going on, in that drafting of human rights covenant also, I will just tell you what I have referred. I have referred here that travo preparatory, that means the preparation background of the negotiation. There you will see that none of the Western European nation was ready to consider permanent sovereignty over natural resources. It is only the Russian support, the then Soviet Union, which was there. With their support, permanent sovereignty over natural resources was adopted in these two covenants. And gradually you will find that in Namibia situation also, permanent sovereignty over natural resources was recognized as one of the essential general principles. So, what was that Namibian case where Namibian resources were completely appropriated by South Africa? And that is where United Nations stated that administering authorities who are there, administering authorities are also responsible for the protection of what? Of natural resources of that particular place. After that you will find 2007, your General Assembly declaration on friendly relation among the state. In friendly relation among the state, you will find NIEO, new international economic order, that principle was there, but permanent sovereignty over natural resources was not there. Again, permanent sovereignty, although not there in 1970, it has surfaced in 2008 in strengthening transparency in industries and the law on transboundary aquifers in the year 2013. In these two, again permanent sovereignty of resources, it has come. Now, those who support permanent sovereignty, they have to say that since it is a permanent sovereignty over natural resources, this permanent sovereignty can be equated with sovereign equality of state under UN Charter, and once you bring it under UN Charter, I think Alisha you will be able to tell me, once you bring it under UN Charter, that will have a protection of Article 103. I suppose supremacy clause, right? Supremacy clause means once you equate permanent sovereignty over natural resources with sovereign equality of the state in UN Charter, it will automatically get the protection of supremacy clause of UN Charter. But the problem was, West European nation, Africa I am saying no, West European nation has to say that permanent sovereignty over natural resources, whatever it is there, but it is nothing more than a principle. Are you getting it? It is nothing more than a principle, whereas another half has to say that it is a principle state, that is what state has already adopted. So, from this point, you will find this permanent sovereignty over natural resources, it was further strengthened in the case of Democratic Republic of Congo, the last one you will find, versus Uganda. In this case, for destruction of natural resources, what Ugandan police did to Congolese natural resources, for that 60 million US dollar was paid as a compensation only for destruction of natural resources. And based upon that, you have United Nations Security Council's resolution where it has acknowledged the fact that permanent sovereignty over natural resources, it is a backbone of any nation. So, this backbone of any nation means as a part of act of war or scorched earth policy, one cannot destroy the natural resources of another nation. Now, from this point, we go to the aspect of permanent sovereignty over natural resources in the context of international human rights law. Please remember, it is a general development. Now it is a phase-wise development. Phase means how during the time of international human rights law, how this concept has developed. Now, it's interesting to read, I will suggest all of you to read this part, the report of United Nations Human Rights Commission. UN Human Rights Commission, when it was drafting these two human rights covenant, at that time, it was Chile who proposed that right to self-determination should include permanent sovereignty over natural resources. And at that time, Western European nations stated that it is only a principle and not a right, and United Nations Human Rights Commission is not a competent body to deal with the issue of rights and duties of the state. You will find the drafting of these covenants were delayed. Only reason was that the segment of developing countries, they wanted and they prepared the draft also. And draft treaty says, the draft provision, specifically the draft provision that is there, it says right to self-determination includes political, economic, social self-determination. I am talking about draft. Second clause of the draft very clearly stated that administering authorities who are there, administering the occupied territory, with reference to Namibia, do you remember we have referred Namibia? With reference to Namibia, they very clearly stated that when these administering authorities are there, those administering authority has to make sure that the natural resources of that country is utilized for the benefit of that country only, and it is not utilized for any other purpose. And draft number, that is the third clause of the draft, stated that permanent Soviet right to self-determination includes, permanent sovereignty over natural resources, which was later on adopted in these two drafts. And later on you will find the strong statement of these two drafts. It also appears in the African Charter of 1981. African Charter of 1981 states that the African nation has complete control over their natural resources. Any spoliation or any disposition, it shall amount to compensation. Some compensation has to be paid. Third clause of African Charter is saying that African nation shall utilize all the natural resources, their natural resources, for their cooperation, mutual exchange under international law, for the best practices, for the best welfare of the people. They will use their natural resources. And lastly, they are stating that they shall debar all kind of foreign exploitation on their natural resources. Please remember, like CHARD, that is Charter on Economic Rights and Duties of the State, African Unity Charter is also not a popular one because of the strong statement that is there in the African Charter. Now, soon after African Charter, I think many of you can identify 2007 Declaration on Indigenous People. Now, what is that 2007 Declaration on Indigenous People? Indigenous people can control, own. They have a right over their own land, on their own community. Getting it? They have a control over their territory resources, right, over their land. And any disposition is not allowed. They must be given a compensation. And one most important thing that is recognized in this case, Mayagna Sumo Awas Tingani community versus Nicaragua, it's a decision by Inter-American Courts of Human Rights which states that it is the duty of the state to demarcate the land that is belonging to indigenous community. That is an essential duty. Even adding to it, I think those who are reading corporate law, they can identify OAO Naftania Campania, UCO shareholder case, 50 billion US dollars so far, what is awarded here. But one of the essential element here was what? The manner in which the expropriation was done. Okay, the manner in which expropriation was done, it was outrageous. Now, from this point, we straight away go to the PSNR in the context of international investment law. Permanent sovereignty of natural resources in the context of investment law. Now, please understand here one thing. When we did human rights law, you have seen how it has gradually developed. Now through 2007 declaration, further through these indigenous cases which are there, now it is acknowledged as one of the essential rights of people. Now, when we come to investment law, you understand the game here. I hope I have made it clear. 1962 resolution on permanent sovereignty. Are you clear on that? 1962 resolution. I am asking the students. 1962, please remember, use, possess, regulate, nationalize the resources. What is the essential thing there? Compensation. If you are not happy with the domestic way, you can go for what? Yes, you can go for international arbitration. Now, please remember here, there are two formulas that is applied here. One is Hull formula and other is Calvo doctrine. Hull formula is a westernized formula. What is that formula states? That if there is any violation, means you have expropriated my natural resources, my asset, then in that case, in which place I will go? Hull formula says it will be addressed only through international arbitration. Okay? Whereas Calvo doctrine will say that there is no need to go for international arbitration, it can be settled within the domestic court. Are you clear or not? It will be settled within the domestic court. Okay? Now, with that background, keep that background in mind. Now, Charter on Economic Rights and Duties of the State, if you remember, what does the Charter say? I already told you. What is it saying? First, regulation of investment, supervision on transnational corporation. I told you, no? Supervision on transnational corporation and the payment of compensation. Compensation shall be paid how? According to, yes, it shall be done by the domestic court, basically, keeping in mind the national priorities and everything. Now, here you understand the point of contestation. Here, permanent sovereignty over natural resources, it is a very popular concept. Why it is a popular concept? Because it is not as complicated as CERD. It is not complicated. Compensation will be effectively paid, and what is that? Prompt, adequate, effective compensation. You can get compensation from international, that is your arbitration panel if you want it, if you are not happy with the domestic law. That is a simple formula that is provided there. That is why what you will find is that when this permanent sovereignty was applied, Western European country had no objection with respect to permanent sovereignty. But when chart came into existence, CERD, that is where number of questions were raised by the Western European country. What were those questions? That if the provisions are so stringent, how can we come and invest in your country? Why should we invest? And Chile's answer was that why are you afraid of this provision at all? It is there for our safety, our regulation. Anyhow, you can come and you can invest in our country. You are most welcome if you are coming, right? Now, the problem here was that majority of the Western nation, they consider Charter on Economic Rights and Duty as a fundamental departure from the traditional international law. That it's a fundamentally, it has deviated from the international law, traditional international law. Okay? So, that's where you will find what is the way in order to get the investment done. What is the way to come to a common platform, you can say. Now, that way was devised by means of bilateral investment treaties. I hope I am making myself clear. Bilateral investment treaty, understand the thing, chart is in my way. Now, how to mull the situation, how to dilute it? The best way is to introduce bilateral investment treaty. What are these bilateral investment treaties? What will happen? What happened basically? As a developing nation, you require investment, you invite investment. Obviously, I require it. As a Western European nation, they also require to invest somewhere. Now, when I require investment, I am inviting you. Who are you? Western European nation. Now, when you are coming to my country for investment, what these countries are doing, especially these developed Western European countries, they have devised this policy of bilateral investment. That means what? I will invest, concession agreement will be there, stabilization clause will be there. Along with this, what will happen? Obviously, I will invest in your country, but I have few conditions. What are those conditions? In case of any dispute or nationalization, the matter shall be referred for international arbitration. And that is where ICSID, International Convention on Settlement of Investment Related Dispute, this particular organization that is there, that segment, that will be the place where we will refer the matter for dispute. Are you clear? I suppose the student body who are there, are you yes or no? Yes. Okay. So that is where you will find bilateral investment treaties. That is where it has come into picture. Are you clear? Initially you will find everybody was running after bilateral investment treaties. It was like hot cake. Now, gradually what happened, you understand there are certain problems with bilateral investment treaty. First thing, the duration is very long. 60 years, 50 years, that is the long duration of concession agreement, right? Now, during this whole duration, if there is any shift or any requirement of increase in the share of profit and everything, obviously the nation who is investing may not prefer those kind of demand. Understand, 60 years, 50 years, it's a long time, very long time, many things will change. So during that time, if I am asking that share of profit should be increased, you may not agree to it. You are an investor after all. That is why what happened, as many disputes as possible was coming up because of this bilateral investment. Okay, dispute has gone to that extent that all the nations who were previously inviting bilateral investment treaty, now what they did, they started terminating it one after another. Starting with Ecuador, they cancelled, they terminated 9 of their bilateral investment treaty. Just imagine. Venezuela, who was there, Venezuela terminated all the treaties that they had with Netherlands. I hope you must be aware about Russian position. They entered into Energy Charter Treaty. Right? They entered into Energy Charter Treaty. They have signed Energy Charter Treaty, but they have not ratified it. And in between that, see, when you are signing it, at that time only Russia could have made a provisional declaration that its transitional provision shall not apply here. But that was not done by Russia. That is why this UCO case that they had to face with. Are you clear? So, one after another, South Africa, if you see, all the bilateral investment treaties that they had with Spain, Germany and your Netherlands, Belgium, everything they terminated. The reason that is given by these nations are that, the reason that is given by them, the precise reason is that these bilateral investment treaties which are there, whenever there is any kind of dispute, it is decided by people who are mostly from Western European countries. Now, those arbitrators who are from Western European countries, they are not aware about the problems which are faced by whom? By the people who are belonging to these developing nations. That is the reason why what they are doing, that is the reason they are giving this award in million, billion, they are giving it. They are not understanding the situation. That is the reason why you will find that this particular bilateral investment treaty, once the termination started, that means again you will find people, once they realized that investment is not something that people will invest and go away. Because there is a general principle of law, pacta sunt servanda. Okay, once you have entered into a treaty, you have to respect the terms and condition of treaty. Now, when you have to respect the terms and condition of treaty, that means what? That means for 60 years you have to tolerate that, whether you like it or not. So, after this experience, what you will find? People started going towards what? Principle of, again, principle of permanent sovereignty over natural resources. Again, they are going back to this. Now, in Indian situation, you will find, we have model bilateral treaty, that text that is there. Now, in Indian situation, we have a very conflicting situation. Indian situation is stating that Ministry of Commerce that is there, they are in favor of termination of all the bilateral investment treaty. But Ministry of Finance that is there, Ministry of Finance is against it. Now, when you see that bilateral investment treaty that is there with respect to Indian aspect, you just go and check the compensation railing. We are also following the international compensation scheme. That means prompt, adequate, effective, according to market value. That compensation has to be paid. Now, if you see the entire discussion, throughout you will find there is a conflict, but in the conflict one important thing we will see. Arbitral tribunal in no way, in no case they are denying the fact that permanent sovereignty over natural resources is not the fundamental rights of the state or it is nothing to do with the nation. They are acknowledging permanent sovereignty over natural resources. Nations do have this thing, as long as they don't invite the investor. If they invite the investor, what is the issue? That sovereignty thing, they have to submit it and it will be subject to the interest of the investor. Now, behind this, there is one very fundamental thing. With that I will come to conclusion. A very fundamental question that comes, that why this is the situation? Why permanent sovereignty is treated as something like second hand, or there is always so much of debate here? See, main reason is that you will agree to one thing, that international law is mostly Eurocentric law. Okay? It has never developed permanent sovereignty over natural resources. It was always taken up by developing nation. Developed nation, except France, none of the nation, even today also, it is France who is supporting. Other nations which are there, they have a kind of, they are not advocating or they are not comfortable with permanent sovereignty. See, they have accepted 1962 resolution. There is a reason for that acceptance. They have accepted why? They accepted 1962 resolution because the compensation regime is clear. But when it comes to CERD, they have not accepted it. You will find Taxeco arbitration where the arbitrator has declared that CERD is nothing but it is a political declaration. It cannot be considered as what? As a resolution, or it is something that is the voice of the people. So we don't acknowledge CERD, but we do acknowledge permanent sovereignty over natural resources. So that's where you will find, since there was from the beginning there was a strife, that whether it is a principle or whether it is a right, some part will say yes it is right. For example, you will find our developing countries will say it is a pre-entry norms. Okay? Then they will say it's a customary principle. Right? But developed nation will say it is nothing, it is just a general principle of law, and since it is a general principle of law, leave it like that. Beyond this, we are not going to acknowledge it. So, the major problem that is here, and this problem continues, it is not that it happened at that time. Even now also, this is a problem which goes on, and mostly because the issue is that here, that since there were so many strife, division in the development of this concept, permanent sovereignty, that is why it is not popular universally. It is fragmentally, it is popular. That means one part of the nation, developing nation are liking it, developed nation were somewhere against it. So, that's where what I feel, see, all the problems which are there with respect to permanent sovereignty over natural resources, it lies with respect to investment. Investment means I have a sovereign right over my natural resources. When I am inviting you and when you are investing in my country, that 60 years of concession agreement, this is what I feel. This 60 years of concession agreement that you give them, that for 60 years you use it, in that 60 years, if there is any terms and condition which includes that with the changing year there should be a revision, if that clause, revision with respect to sharing of profit or anything, then there is a possibility that this situation of termination of bilateral investment treaty or this anti-feeling against bilateral investment treaty, the same can be minimized. Thank you.
Good evening everyone. Now I am here to give a formal vote of thanks. I extend my gratitude to the Honorable Vice Chancellor and to the Registrar. Thank you, sir. And importantly, I thank Soma ma'am for the wonderful lecture. Actually, it was a consistent, energetic lecture which included the developments of this, the so-called permanent sovereignty over the natural resources. And ma'am also discussed how this contestation has acquired through various legal battles, and she laid emphasis on the international human rights and international investment law. Thank you so much, ma'am, for that lecture, and thank you, dear faculty and also students, for your participation. Thank you, IT department, and thank you one and all for making this weekly lecture series a grand success. And thank you so much. I think I can make this announcement that in the next weekly lecture series we are going to have K. Sudha ma'am. The next future weekly series, you can please come up. Thank you.
If they give their name now, they'll have 1 month to prepare.
Yeah, exactly.
If they don't give, they'll have 1 week preparation.
Exactly. You'll be having 1 month of preparation.
Yes, sir.
Thank you so much. Thank you.
Thank you.